everybody. What's going on? It is Monday night here on LTL. I want to welcome everybody into the live stream here. And it is nice to see everybody this evening. And the three amigos are back here live on the show. And we're going to get into the Karen Reed civil trial tonight. I'm calling this round 3. This is like round 3. And I talked about this. I had done this presentation the other night on my show, and it did really, really well. And I wanted to bring in Todd and Nan to actually talk about this tonight as well and go through that. So full disclosure, this is like 2.0, but I want to get their thoughts on this and get some feedback as to the two professionals that are in this business. We'll get a lawyer's perspective and obviously a retired Mass State Police officer perspective as well. Before we do that, we're going to get into a little of a Sandra Birchmore update. I'd love to hear Todd and Nan's perspective on that, but let's not wait too much longer. I'm going to bring everybody in here on the panel. We'll bring up attorney Nan Gallagher first. Hello, Nan. How are you?
I'm great. How are you?
I'm doing great. Hey, we're back here Monday night, like our Monday night regular. I think we've done 2 in a row now, and it's nice to see you back here, and nice to have the three of us back up here again.
Always. It feels like coming home again.
Exactly. I love it. And Mr. Todd McGhee, welcome back to the show.
Hello, everybody. Nan, you're rocking that cap. I love it.
Thank you. It's good to see you, Todd.
Good to see you, my friend.
So it's good. It's nice to see everybody here. Everybody's saying Todd, they love it. Hi, Nan. We love you. Nan, lots of support. Love you, BLT and Nan. Love it. Here for Nan.
I'm here for Todd. I'm here for Todd.
Yeah, love this panel, Allison. So we're back on the Monday night panel here. So we had obviously we're getting ready here. Karen Reed civil trial doesn't look like it's going to happen until 2027 apparently. And the judge the other day was basically like, look, if you guys want to do this, it could take a few years. And I personally said that I think we're probably looking at maybe 2 to 3 years, and I'm only speculating. But that's what I think, and I'd love to hear, what your all opinion is, because I've been talking a lot about it. I'll do this. I'm going to go to Todd first. I'll default to Todd. Civil trial, Todd, round 3. I'm calling this round 3. What do you think? What do you think is going to come out of this? Karen's going to countersue everybody. It's going to get ugly, and I said it's going to be really, really ugly. But I gotta hear your take on this.
Yeah, I thank you, Brian. I got a chance to watch the hearing the other day, and what I'm most looking forward to is listening to evidence that Canoni wouldn't allow in. This is going to be a game changer of a trial, and I'd like to hear Nan's take from the perspective of, this is a civil proceeding, but yet there's going to be names of new accused, and we all know who the players are, so I don't need to go down that list, but it's going to be interesting to see how that plays itself out.
Yeah, I'm excited. I am. I'm excited for this civil case. I really am. No matter if it's just defending a wrongful death lawsuit or if it is going to be a combined state action defending a wrongful death suit and then adding as third-party defendants 10 new defendants. In civil litigation, there are rules, but there is wide latitude, which I know we're going to discuss tonight, Brian, in terms of what comes in with regard to evidence. And even if it doesn't, quote, come in before a jury, everything gets discoverable. So you'll start to see a lot of things come to light that you didn't see in the criminal matter. And then there will be in limine motions right before the civil trial in which the parties will bicker and fight and argue over, should this come in before a jury? Is the prejudice too much versus the benefit of the information? So it's going to be the best sunlight, putting the best transparency forward here. Lots of questions, lots of answers that we just didn't have access to under the constraints of the criminal system.
Yeah, there's no more protection from the corrupt DA's office. That's why I'm saying, I'm going to say it in my presentation tonight. I was saying it the other night. You got to be ready, O'Keefe's, because you're going to have to show all your stuff too. You're bringing this suit forward. you're going to have to show everything that you have. So everything is going to be out there in fair game on the table in this, and wait till we, the depositions start. From what I'm understanding, and this, and maybe you can clarify this, Nan, deposition obviously I've seen a billion of them. And basically they can be held back, but they can be brought in as evidence, correct? Or how's that work?
Yep. The depositions, which are out of court sworn testimonial proceedings with a court reporter, those get memorialized into transcripts, and those transcripts can be presented to witnesses to cross-examine them or to validate their testimony or to ask them questions about. So the transcripts themselves don't come in to evidence to the jury unless there is a particular area where there's a conflict between the testimony and what the witness is saying. But depending on the court's rules, lawyers are permitted to actually read not only the deposition transcripts to the jury in part, but also to read what's called answers to interrogatories to the jury. Those are written questions with written answers that the parties must exchange. And I got the sense that those answers to interrogatories have already been provided by the O'Keefe family to the defendants already. So they've already put their position in writing. We don't know what it is yet, but there's no protective order. That may come to light just through a natural course of leak. I'm waiting to see if we start seeing what their interrogatory answers say.
This is interesting too, and I love Leslie's question here. So I'd love to know how the plaintiff's attorney are going to be able to afford and hire experts that are going to be able to counter ARCA. I mean, Todd, you speak to this stuff. You speak to security. You've been a former Mass State Police trooper. You know how expensive all this stuff is. These experts to come in. Talk about that a little bit. I mean, are they going to have the funds to do this?
Brian, I've some of the cases that I've worked on. There's been PhDs that are hired by counsel. They're $500 an hour.
Mm-hmm.
Now, when you start hiring companies, $1,000 an hour, $1,500 an hour, I mean, that's real money.
And if I can just add to that one little note, which is, even if the O'Keefes have retained their attorneys on a contingent fee basis, which means the attorneys recover only if the O'Keefes recover, most attorney retainer agreements are set up in such a way that the parties themselves, the plaintiffs, the O'Keefes, must pay for the experts. That is something, that is a cost that 99% of any plaintiff's attorney will not take the risk on themselves. So the O'Keefes will have to pay for their experts. And even if it is Aperture, even if they say we're going to use Aperture, or we're going to use any other expert like the Jessica Hydes and the Ian Whiffins, those experts will have to be paid again, even if they're not conducting new testing and they're simply kind of refreshing their recollections as to the foundations for their prior opinions. There will be travel and testimonial fees for both their depositions and their trial testimony, and I can tell you, it's going to be in, by my estimation, the hundreds of thousands of dollars to do that.
Because this is not, like, people have to realize this is not going to happen overnight. Like, if this gets stretched out and doesn't happen until 2027, it's going to be the same thing like Karen had to do. You're flying in all these experts, you're doing depositions, you're getting, opinions and thoughts, and putting together presentations for evidence. I mean, this is, do you think that the O'Keefes have thought this out? I mean, who's backing this?
And the longer it goes, the more expensive it gets.
Yeah.
That's probably one of the most important questions that I think needs to be asked here. I believe that the O'Keefes were short-sighted in whether they should do this. They were facing a 3-year statute of limitations to institute a wrongful death action, so they had to file it in January. With that said, they trusted, from my observation and in my opinion, they blindly trusted those who were within the sphere of knowledge of what really happened. And that includes, in my opinion, the McAlberts and certain specific law enforcement personnel and the district attorney's office, that they were getting a true sense of the story, that blind trust led them astray. And unfortunately, they put all of the, quote, rubber ducks in the wrong basket.
Yeah, I almost wonder if like just this lawyer came at them and was like, "Oh, I know you want to do it, have a civil case. I'll get involved. Let's just push." And then, they really sit down and see the scope of this, of how much this is going to cost, and then, maybe they just carry this thing on. Like the question was asked with Jackson outside of court the other day, is there an opportunity to settle? And he said, there's always an opportunity to settle. So maybe they just turn around and say, well, we'll just push the civil case. She's not going to want to go through it for the next 2 years. Hopefully we come out of this with a couple $100,000 or $1 million or something like that. Could that be the fact too, Todd or Nan, if either one of you want to speak to that?
Yeah, without any admission of guilt or wrongdoing or anything else like that. I think lawyers can craft nice language. Dan, this is in your wheelhouse as well. But I mean, what's in the best interest of the client at the end of the day?
Best interest, that's the great question. In the best interest of a client, it's not to go to trial. It's to resolve a matter by settling it. It doesn't mean that anyone's admitting liability or anyone's conceding that there wasn't a great case to present, but trials are uncertain. Trials are risky. No one knows what a jury's going to do, and that applies to criminal actions as well. If I were to suggest something to the O'Keefes right now, and I don't like suggesting anything to them, but I would settle a quick and dirty settlement with the bars, and I would be on my way. I would voluntarily dismiss Karen, and I would just hold my head low and move on my way. Because if this proceeds any further, it's going to backfire. One last point while I'm thinking of it is that if and when the Karen's team brings in these 10 new defendants, and let's assume they do come into the state action as third-party defendants, the O'Keefes, they have a choice to make. Are they going to then also name these 10 new third-party defendants as defendants that they themselves are suing? Okay, it's not enough to just sue Karen and let Karen sue the 10. So if the O'Keefes do not choose correctly, I might add, if they do not correctly choose to then individually name and sue these 10 new defendants, then I believe, and I'm right on this, their attorneys would be committing malpractice. So if these 10 come in, the O'Keefes must advance claims against them, or else the attorneys for the O'Keefes are committing malpractice. And if it is, and it's very complex, Brian, I could do a whole separate show with you on this so as not to waste Todd's time this evening, but it's pretty high level legal acrobatics. I've been in this type of situation many times before. It is not enough for Karen to sue these 10. The O'Keefes will never see justice in their minds if they don't then individually name them as well.
But wouldn't that make them look like hypocrites? Because I was even saying this when I did the show, the other night. And again, I'm being transparent. We're doing a 2.0 here. I wanted to bring Todd and Nan to get their opinion on this. And we'll do the presentation here in a second. But wouldn't they be hypocrites now because they rolled with them through 2 trials? I mean, these were their BFFs. Those are the people that they wanted to believe. And I was even saying on my live the other day, was like, look, if this happened to me, okay, and I'm putting my mom in the shoes of Peggy, okay, if this happened to me, and my mom would literally be, and my mom can't drive, my mom's legally blind, she would have someone drive her over to 34 Fairview the morning of and start knocking on the door and say, there's a bunch of people here the other night, we gotta ask some questions. But that didn't happen because the mind was already made up that it looked like, it looked like John was hit by a car, and you already had Proctor with 12 hours in has already made his mind up, and everybody inside that house has already gotten to Peggy and started to spin this story.
Yep. Yeah. I listened to that show of yours and I thought it was great because my mom would have done the same thing. But I will say one last thing, which is it is not too late for the O'Keefes to open their eyes and realize that the only way they're going to get any modicum of justice and recompensation for themselves, it's not too late for them to say, you know what? We're going to also name these 10 as defendants and see how it all shakes out. It's not too late to eat crow. Okay. And if I were them and I got into bed with the wrong people and I said, I want to have my soul restored and my piece of the pie, and I want to make sure the 2 children are taken care of through their lives, I would say, you know what? Let the defendants, including Karen Reed and these 10, let them all, and the bars, let them battle it out. But we, the O'Keeffes, are not responsible. Let those defendants point fingers at each other and let a jury decide what proportion of fault each of them carries. And Karen could potentially get nabbed with part of it. I don't know. I know she's factually innocent on a criminal level, and I know she didn't hit him with a car and that he wasn't hit by a car. But the O'Keeffes have an opportunity now to change their fate, legally speaking. Very, very high level acrobatics, but happy to discuss further.
Yeah. Colleen, 17-month member, thank you so much for being a member and a supporter of the channel. She says, Nan, is that why they didn't want to their cases to merge?
That's likely true, Colleen. Also, did we lose me?
Yeah, I'm here.
Did we lose you? Did we lose our host? Colleen, that's likely true. And also the addition of 10 new defendants also adds to the complexity, the time, the deadlines, and the costs to the O'Keefe family. They're going to have to answer 11 sets of, 13 different sets of interrogatories. They're going to have to take all of these depositions, pay for all of these transcripts. The costs of the trial, if the 10 defendants are added, will increase exponentially. So that is why also they don't want these cases merged.
Yeah, our intro was fairly long, but I do want to let's do this first and then we'll get into the presentation tonight. And it was a great intro, by the way, too. I appreciate that. Great open tonight. But I want to talk about the Sandra Birchmore case because there was an update a couple of days ago. So this had been going on in her case. Ex-cop barred for life in Massachusetts over conduct involving Sandra Birchmore. So it says former Abington School resource officer Joshua Heel, who was a witness in a federal murder investigation of Sandra Birchmore, has been permanently barred from ever serving as a law enforcement officer in Massachusetts. Ever serving as a law enforcement officer in Massachusetts. Am I hearing that right, Todd? So apparently he can go out and let's say he goes to California, he could get post-certified again and become a resource officer or a police officer in California.
Yeah. So this latest update with his status of no longer having status applies to Massachusetts only. If he goes out of state, they're going to want to know what he's done for the last 9-10 years. So it's going to follow him no matter what.
Got it. And then they will have to make the decision. But it's interesting because if we go back and look at the, was it Sandra, what was her last name? I'm going to get this wrong too, and I'm sorry.
It's okay.
Massey. That officer that shot and killed her had a history of this, and he carried decommissions along in his career, but it was ignored. Am I right on that?
Great. It was Grayson.
Grayson.
He retired before any type of departmental sanctions. So he basically lateraled around the counties or whatever region of the country he was in and just kind of, hopped from police department to police department.
So he worked the system. He knew how to get out of this so he could just keep working.
Correct.
Yeah, it's great how that works, huh? Honest police officers. So it says the ban was finalized by the Massachusetts Peace Officer Standing, and that's the Training Post Commission on September 25th, 2025. The Post Commission order states that Heel shall never apply for certification as a law enforcement officer within the Commonwealth of Massachusetts and shall never seek or hold employment by any law enforcement agency in the state. Okay. The action against Heel stems from sustained allegations of misconduct, including the accusations that he lied about a sexual relationship he had with Sandra Birchmore when she was a young adult. The Abington Police Department found Heel engaged in, quote, conduct unbecoming an officer and was untruthful during multiple interviews. And we've heard that before, unbecoming an officer. And I believe that's what Michael Proctor was charged with as well. Am I correct on that one? Yeah.
Correct.
Yeah. So it goes on to say, Abington Town Manager Scott Lambese reported the commission's ruling, stating that he was, quote, glad this is over and behind us, and that this outcome is what we anticipated and we hoped for our recommendation. I think this is probably best. I'm just going to put this out there. This will never, ever, ever be put behind anybody. I want all of these people to remember, because I'm pretty sure that a lot of these people knew about this and kept it under their cap because they didn't want to be exposed and they didn't want to have anything or any connection to do this. So I hope all the people that were superiors, and God forbid you knew about this, I hope it carries on in your life forever, because Sandra Birchmore did not deserve what she got from these animals that groomed her, and then one of them ultimately ended up murdering her. So I hope this lives on your conscience forever. This will never, ever be excused or forgot about in the state of Massachusetts. Not while I live, and probably not why anybody in this chat lives or people on this panel. And I'm sure that I can speak for the wonderful people on this panel of what I just said. We will never let you forget, and that this is behind you. That's a gross quote. So it says, Heel met Birchmore in his previous job working as a Stoughton animal control officer. His name appeared in an internal affairs report that accused Stoughton police officers of sexually grooming Birchmore when she was a minor. A recording leaked to investigative report Ted Daniel last year revealed that Abington police officer Chief David DePapa said Heel had intimate knowledge of Birchmore's involvement with Stoughton officer. DePapa said Heel admitted to having sex with Birchmore when he was a young adult, stating that the allegations had, quote, exchanged for a cat or some oral sex was true. DePapa found Heel to not be credible according to the recording because Josh denied having a sexual relationship with Birchmore during the first interview, but he had changed his answer in the second. This whole thing is disgusting. These people are gross, and I hope that every single one of them go down. And I will digress and open it up to the panel.
I concur. Go ahead, Todd. I concur.
Yeah, no, it's just, so many of these different cases are happening, not just what's going on in Massachusetts, public safety, but around the country. And it's just good to see that the system was implemented and the system followed through with the right decision. That it just seems like too many of these stories get kicked down the can gets kicked down the road. There's some sense of early retirement. When there's people that are really need to be held accountable and shouldn't be in the profession. And when I do different interviews with the media and I get asked about these types of police misconduct, there's good and bad in every profession. And it's unfortunately, we like to hold law enforcement in high regard, but that's earned. That's not given. So it's a matter of, the good men and women continuing to do the good work for their departments, protect and serve, and to call out the one percenters that are, ruining the badge and ruining the good name of law enforcement.
This is going to infuriate you, Todd, when you hear stuff
horrible.
like this.
Because I know good cops that go to work every day and would never in a million years get involved in this type of shenanigans, but yet the general public lumps. It's just the nature of the beast. Law enforcement gets the good men and women get pulled in to the negative press, and as much as it's unfair, and it should stand alone, it is what it is. And I don't blame the general public for being upset and disconnected from public safety.
Yeah.
Yep.
And this guy needs to go down too. I mean, feds need to look into this guy too. If there's allegations out there and there's proof out there that he was involved in this, he needs federal charges as well too. Go ahead, Nan. Sorry to cut you off.
It's interesting when I hear stories about this and where there's kind of lateral moves. I think of two things. I think of the Catholic Church scandal. I'll just say it and step off of it. And I also think about my specialty of practice, which is healthcare law, criminal, civil, administrative. In healthcare law, when doctors get into trouble in the employment setting, whether it's they've done something wrong in a hospital and they're being investigated, there's inappropriate conduct, they're being investigated, or there's news that they're going to be investigated. There are state laws in almost every state that prevent doctors from having lateral moves or resigning pending investigation or to avoid investigation. When doctors do that, it is reportable to the federal government, to a federal database. That way, anyone else, any other agency, Medicare, you name it, they all become aware. So every other state understands not only whether someone was actually found culpable for doing something wrong, they are also made aware if there was a move to avoid having been found culpable. So I wish they had, and I do not know if they do. It sounds like they don't. I wish they had a measure like that where if there is this kind of early retirement, lateral moves, means of avoiding ultimate finality of an investigation, which harms people. It harmed Sandra Birchmore. It's harming other people. I wish they had that for law enforcement. I frankly don't know if they do, but I don't think they do.
Yeah, there's nothing in place.
The Irish
The only thing that a senior administrator could do is pending criminal charges, they can postpone a retirement. But that's internal administrative action.
Yeah. If I were to give a recommendation to anyone, it's consider lobbying for something like that. Accountability. You know, one of your major platforms, Brian, is accountability and holding people's feet to the fire and effectuating change through journalism and just activism. Having this type of transparency amongst agencies and states and getting people to put their eggs in that basket would be a wonderful cause. I'm not saying you should do it, but if I see a creator is going to do that, I'm going to throw everything I have into supporting it.
Yeah, Irish Rover, and I'll let Todd answer this. Is it because the good cops don't really do anything to remove the bad ones due to, quote, the brothers in blue?
You know, it's a great question, Irish Rover, but you know, as a fellow officer, there's nothing I can do to remove someone from the employment from the agency. They're a civil service employee of a government agency. Now, can I pull someone aside and have a conversation? Absolutely. Have I had those conversations? Absolutely. You're not going to do that and pull me into your potential internal affairs investigations now.
Yeah.
Right. So those conversations from back in the day, those conversations were had. But you know, but again, it's up to the individual to fly straight after that. But you know, but to end someone's employment is it's just not an option.
Yeah, and Todd back then looked like he could throw some down. So he was. I've seen some previous pictures when you were in Todd. You were there.
My fight in white. I could dance a little bit.
Yeah,
I love it.
Let's take this real quick before we get into the presentation. NH2 603 $20. Thank you so much. I appreciate the support. Says hello, boys, and hello to my Joyzy girl saying hi from Munich, aka Insomnia. So thank you so much. I appreciate that. I appreciate that. All right, let's do this. We'll share my screen here. So I said the other night when I went into this, and I kind of point this, you know, are you ready? You know, are we ready for this? Is everybody ready on all sides? I can tell you this. I'm pretty sure with the outstanding lawyers, and I love the fact that now Alan Jackson is part of, you know, this civil team, and it looks like he's going to be, you know, probably some more guidance, and we'll have some some expertise obviously into the two trials. So being there to guide Karen's civil lawyers along this way is going to be really great, because he knows this case back to front. Karen knows this case back to front. They're going to know the witnesses, which is phenomenal, and how they're going to react, and what things that maybe during the criminal trial they were protected on, that they can get and ask these questions now in depositions and during this trial. So, I just threw this up. What are the key differences between a criminal and civil discovery? Criminal trial, discovery was limited by the prosecution due to disclosure, exculpatory evidence, Brady Giglio, and by Rule 14 of Massachusetts criminal procedure. Many documents and witnesses are shielded by prosecution discretion, claims of irrelevance, and or ongoing investigation. Civil trial, that opens it up to this. The parties, Reed versus John O'Keefe, which is actually the other way around. O'Keefe's versus Reed, estate and others, can serve interrogatories, requests for production, depositions, and subpoenas. The threshold is much looser, and any reasonably calculated to lead to admissible evidence is discovery, even if it wouldn't be admissible in a criminal case. Nan, can you speak to that? Reasonable, calculated to lead to admissible evidence. It's a lot to say.
It is. In a nutshell, what this means is, in a civil proceeding, the court has allows a very wide latitude for what can come in before a jury. So you can explore anything you want with the other side, and if it is pointed in a direction that is relevant and it's not going to become any problem from an evidentiary standpoint, like it's not too prejudicial, it's not including hearsay, it all comes in. So if it's admissible evidence, there's a wide net that can be cast. And that's, like we were saying at the top of the show, in a civil matter, there's just the open floodgates of what will be allowed to go before a jury. And this is, it's great news for the defense, for Karen's defense. They're going to get to see what's behind the Wizard of Oz's curtain. Yeah.
We're gonna get everything in that, and that's what I love about this. That's what I love about civil trials. Everything gets opened up. Everything gets opened up. So, what discovery could surface in the civil trial? So we ask depositions under oath. Expect sworn depositions from all the key central figures, and I don't have all the names, of course, but we'll just say the McAlberts, and you all know who that is. We're gonna probably see this fun bunch again too. Proctor, Bukaki, Tully, Guano, they're all going to be in there. We have the federal and state law enforcement liaisons, Canton first responders. Oh, and by the way, DA Michael Morsi could be called as a witness as well too. So, and then in the criminal trial, defense attorneys in civil cases can ask open-ended probing questions, and evasive or contradictory answers could be locked into the record. So, Todd, what do you think could be some of the things that maybe the Mass State Police, the Three Stooges, I call Proctor, Buchanan, and Tully, could be asked that was probably protected in the criminal trial?
Yeah, I think, Brian, we need to go back to the actual investigation and start to examine the holes that were evident in the investigation. That's where I would start, and from there you can segue into why were reports held onto, what happened to the chain of custody with evidence, why were things the crime. I can actually explain the poor crime scene, but from reestablishing the crime scene to the search with the CERT team, those are areas that are full of holes that a jury will listen to and say, something stinks here. And if you remember, in Buchanan pushed it really in the second trial, trying to protect Proctor, but he said the investigation had integrity. Well, no, right? And so Karen's attorneys are going to be able to pull apart layer by layer on how there was no integrity and how the investigation was not honorable. So those are areas that I would start and just exploit.
Yeah, I love that. I'm just going to do this, and excuse me for 1 second. I'm just going to pause really quick and just go full screen. I'm gonna tell you. Hang on one second.
That's a lot of Todd right there.
It is a lot of Todd. Let me just do this really quick.
I'm glad I was ready for it.
Oh no!
There he is again. There he is again.
Todd in the back, real quick. No offense, Todd, but I'm trying to. I'll just do it this way. I'm gonna tell you right now. Okay, if anybody is gonna come in and harass people on my panel and say shit about them on my panel, I will bounce you, and my moderators will bounce you so quick from my chat. That is not what we do here. We come in to do these panels to be productive, okay? If you want to bring your drama and your attacks, go somewhere else. There's plenty of other outlets that you all can do that on, okay? But I'm not going to have panel guests that give their time to come up here and do this and give back to people that want to be here on this channel, in this community, and learn something, because I love doing this because I get to learn from this too. But you all need to be respectful to the people up here on this panel. If you don't like it, you can leave, or my moderators will bounce you out. I'm sorry to be rude to interrupt that, but I just wanted to make that statement. So let's move on. Okay, so we have phone, text, and digital records. Now we have a broader subpoena for cell phone extractions and deleted text recoveries. Where did we see that? Jennifer McGhee. Google location history, social media activity, which I'd love to see that. And I'd love to see more of things on the messaging apps too, because we didn't really see a lot of that. What was some of the backroom chatter? What was some of the things that possibly could have been said? What is some more of the text message? We're going to see everything. And then we have the internal police, the police and DA documents discovery that can be forced exposure of. One, internal affairs records. We've heard a lot about that at Proctor. That's going to all come in. Misconduct, disciplinary investigation officers, emails, chat, memos, communications between the Norfolk DA's office and MSP. We've seen a lot of that already. That got exposed. That got FOIA'd. And then budget and investigative cost records. Who authorized what, when, and who. If either one of you want to jump on this and take a little bit out of this segment, please do.
Here's the takeaway here. In a civil litigation, the subpoenas are so broad, you don't see what you saw in the criminal action. Subpoenas will be served upon third parties, and they have to produce everything that was asked for, unless they get a judge by filing a motion to quash the subpoena or to limit it. They will have to produce everything that's been asked for. It goes to the other side. At that time, the other side gets to see all of it. Whether all of it gets before a jury at the trial stage is another story, but they get to see all of how the sausage is made. They get to see all the secrets, everything they asked for, which even if all that information doesn't come before a jury ultimately through the in limine process, they will get to see and learn from what they were able to procure. So it can be extremely informative, extremely directive to attorneys. So this is going to give the defense team a lot of information that's going to help guide their future questioning of witnesses. And really, no one can do a damn thing about it. So if I were the McAlberts, I'd buckle up.
Man, I got a question for you.
Yeah.
Would it be appropriate for Karen's team to ask Tully Buchanan, Proctor? Well, Proctor's, received the harshest disciplinary action, but something to the effect of, as a result of the trial, how did your conduct impact your employment?
As a result of yes, they can ask that. So in other words, did the trial affect your employment status, or how did it affect your position in employment? Yeah.
While you were investigating this case, it looks like your department took adverse action against you.
That can come in. And also, the parties might argue over whether it should be relevant. There's a doctrine in law called subsequent remedial measures, which basically means you're not allowed to bring in evidence of something that happened as a result, like disciplinary proceedings. You're generally not allowed to bring them in to evidence as evidence that the person did something wrong. You have to point to another reason why it's relevant. for a court to allow it in. Again, this is like the high level acrobatics I was talking about. But what happens is attorneys who want to get those subsequent remedial measures like disciplinary proceedings or terminations, lateral moves, demotions, the attorneys who want that into evidence will find any other legitimate evidentiary basis to get that evidence in before a jury. So I think it's all coming in. This judge, his hands will be tied. He's going to have to let it all in.
I would say allegations of civil rights violations would be a good reason.
Oh, absolutely.
100%. Yeah.
I totally agree.
And Lori's asking, can they still use a text message at Proctor? Of course. I mean, we might hear more. You might see, that the pack maybe in the criminal trial was this big. In civil, we're probably going to see this. There's probably more that's going on, and they're not going to be able to hide behind the protection of Adam Lally or Hank Brennan. Or
that's right.
Everything comes out now.
That's right. And I remember Judge Canoni was limiting some of Proctor's texts. I believe she even limited some of Higgins' texts, if my memory serves me correctly. That's not going to happen in this action. So it's all coming in. And there may be, I'm saying there may be more of Jen McCabe's text messages. They may want to get Allie's text messages. They may want to go after, and I'm not saying this stuff exists anymore, but cell phone carriers, everything. I mean, I'm sure the subpoenas are absolutely flying right now. To be a bird on the wall in those conference rooms would be fascinating to me.
Yeah.
Put your safety goggles on, everybody.
Yeah. Put your shields up. Terry Martins, thank you so much for the 10. She says, do you think they will call Colin? He's a big boy now. Of course. I mean, of course. There's no more protection. This is open. This is an open field now. They're gonna come at everything and anybody and deserving slow. And that's why I sit here and I go, there's no way this thing's settling in like a year. This is going to be a battle. I mean, I think on average 2 to 3 years. 2 to 3 years.
Oh yeah. I was saying 2 to 3 years the other day. I might have said that in your chat, Brian. And the more I think about it, it's upwards of 3 to 4. Civil cases move at a molasses pace, and this is a lot of defendants to bring in. So,
and I love all the
at least 3.
Yeah, I love all these questions. No, I'm sorry, I stepped over you. And I love all these questions too. Tisha say, hey, what about the disposal of Higgins' cell phone at the military base? Yep. They might call, the person that worked the gate that night and have them try to recall, what happened or how did he access and get into that base? Is there camera footage from that base of him going? Oh, that would be interesting to see, wouldn't it? Mm-hmm. I'm sure there's cameras everywhere, right, Todd? It's a military institution.
Can't hide.
And one other factor, which we're not discussing yet, is the fact that with a different judge, there's going to be hopefully, much more openness to not granting all of the objections of the other side. Like what Canoni did by sustaining all of the objections that Lally or Brennan made during trial 1.0 and 2.0, you're not going to see this time. Mm-hmm. So there's going to be very little reason for questions to get objected to. The judge will have to let it all in. So you're going to see the parties are going to be forced to answer the tough questions that we've all been asking.
Yeah. I love that. I love all this because now we can just dive in and just say, no, everything's on the table now. And that's what I said. That's the theme of this. Like, are you ready? You're bringing it. Are you going to be able to show it and want to go through it? So that's my question. So we look at medical and forensic expert testimony. We have full access now to autopsy files, toxicology, pathology reports, and cross-examination of the state and independent experts, expanding chances to question discrepancies in case of manner of death. And what do we know? They hid they hid the x-rays of John for a very, very long time. That'll all be out now. Civil subpoena for third parties. That's the bar staff, neighbors, Canton officials, and even media insurance entities that could be compelled to turn over records. Institution like Verizon and Apple will have to turn over the data this time. You will have to and be allowed to see it. I love civil trials. You get everything. You get everything. JD, thanks for the 10, says if Morsi is booted in the DA election next year, how will this affect the civil suit? He still will be called as a witness. He still can be called as a witness because he was a an entity that held an office during this. So he
Mhm.
will, during this whole process. So he will be called. So we look at why this matters. Civil discovery don't just revisit the criminal trial; it widens the scope. People who avoided testifying in the criminal trial and may have not been called to certain things may now face compelled depositions. Quote, the backstage communications, text, emails, drafts, and reports are far likely more to be exposed. So in short, expect a much larger universe of documents and testimony in a civil trial, especially from people inside the house that night and law enforcement. It could reveal contradictions, suppress details, and potential misconduct that the criminal trial never reached. Again, they don't have the umbrella of the Norfolk DA anymore. That's
Yep.
off the table. Off the table.
And honestly, by the time this matter goes to trial, I'm hopeful Morrissey will be out of office. So it will also add a different layer of openness to this. Like, I don't think Morrissey will win an election if he's stupid enough to run, and it may change the tone of the trial and how a jury actually renders a verdict in this civil matter. I think it will be beneficial to Karen.
Steve says, are the feds watching the civil trial waiting for a reason to pounce? I'm going to tell you, I don't think they ever went away. I think they've been watching, slowly watching. I can probably say for the other two people on this panel and speak for them, I think they've always been watching and collecting evidence and putting this all together. And who knows? You know, the thing about the feds is they strike and they never tell you when they're going to strike. So
yeah,
it's good.
That's true.
So we have criminal versus civil discovery in the Karen Reed case, criminal trial, what we got and what we didn't get, what was allowed, limited discovery under Rule 14, exculpatory evidence, that's the Brady Giglio, witnesses list tightly controlled by prosecution, and select data, text calls filtered by the DA, mass police, and let's even put this in there, Judge Beverly Cannoni. So then what was blocked, internal police plus DA emails and memos, that eventually some of that just came out because we had that FOIA, that big DA Morrissey dump that everybody read through, and there was tons of them. Broader cell phone extractions, deleted, recovered message, internal affairs, misconduct files, depositions under oath by key witnesses, the McAlberts and the officers that are involved. So civil trial, what we'll likely see, depositions under oath, Brian Albert, Jennifer McCabe, Mass State Police investigators, Canton's first responders. You have the full digital records, internal affairs documents, third-party subpoenas, that's Verizon, Apple, if there's Ring, Amazon, bar staff, neighbors could be interviewed, expanded forensics and autopsy files. And then why this matters, it's a civil standard which broadens the net, reasonably calculated to lead in admissible evidence. I love this, no DA chokehold on what comes out. Contradictions, suppressed details, more likely to surface, forces people to avoid testifying, and you have to speak under oath. Bottom line, criminal case equals DA controlled, tight scope, and many unanswered questions. The civil case, again, opens and widens subpoenas, depositions, documents, potential to expose contradictions, misconduct, and hidden evidence. Oh, look at this. Now we'll get to some of the major players here. Before I do, let's just do this. Nancy 20, thank you so much for being a member, and thanks for the 20. She said, Nan, what are the chances of the truth coming out in this civil trial? Actually, I'll open that up to both of you.
Yeah, I actually want to hear Todd. I want to hear Todd answer that first. And Nancy, I promise I'll give you my take as well.
Yeah, please do, Todd.
Yeah, a couple of scenarios I think that could be at play. And we're all kind of waiting for someone to break, right, out of that whole crew. Someone, can't stand the pressure anymore, feels like things are getting a little bit too hot, and whatever they're culpable for, they're just don't want to be exposed. So there's that angle. I was sitting here reflecting and thinking about, we talked about how when Karen was interviewed by the different media outlets, we all agreed that was not probably the best move. And obviously, it was used against her. But also, Proctor did the same thing. The Alberts, the McCabes, they all got together. And I'm wondering if those videos are going to be used and played against them to expose whatever they said in the public eye compared to what they put in depositions.
Yeah.
That's a good point.
Yeah, I agree with that. And to Nancy's question, I I think that it's very likely we will all be able to better deduce the truth, meaning the jury will be better able to deduce the truth as a result of this civil matter. I truly do believe that unless someone folds, and Brian, I saw you put a question up there, like who's going to fold?
Yeah, who's going to
Unless
break?
someone folds, I don't know if we're ever going to know exactly what happened that night, but I think we'll all have a much better sense. Like right now, everyone believes this person did it or that person did it, or we reasonably think these two were involved. I think the chances and likelihood of us knowing more is going to increase substantially as this case is underway.
Yeah, Debbie says, doesn't Higgins have the most to lose? A lot of Higgins in here, a lot of Higgins. And I think maybe, and I'm only speculating what maybe why people are saying this. Is it because, and I want to ask the chat this to the people that did say Higgins, is it because he brought his lawyer in and kind of lawyered up there during the trial? Is that what you are speculating, that he's going to be the one that breaks because he's not going to want to be involved in this? He kind of showed his fear in all this, brought his lawyer in, and his lawyer was there when he testified. So I have the question there to the chat. Let me know if I'm right on that in your speculation, because there is a lot of people. Higgins will cry on the stand. Watch. A lot of people are saying Higgins. We're seeing some Colin.
Adam
very
Teeper
interesting.
has a great comment right under that, Brian.
So Adam says, I think people will fold when the walls cave in, stories will fall apart, and people will start self-serving and start self-dealing. That's a good point.
That's right, Adam. I totally agree with that. I think Higgins does have the most to lose. In my opinion, I think he's probably a sure thing for being directly involved in what happened. The other players, I'm like, maybe they were, or I'm not certain. Higgins, I've always had my strong feelings and opinions about. But Higgins, I don't draw any conclusions based on him bringing a lawyer to court, just because I know a lot about that. And if it was any client of mine or not a client of mine, I would say, if you're going to court and you're being asked questions, bring a lawyer with you. But unfortunately, his behavior and his conduct, the discarding of evidence, the manipulation of evidence, the self-curating, the obfuscation of the truth, that makes him look really bad. Plus, I believe he and the McAlberts are not on communication terms. It's my understanding. And if that's the case, that's always a harbinger for, it's just bad. It's bad news. Like if he's not talking to the McAlberts or they're not talking to him, that from, excuse me, from my professional experience, that's an indicator that someone might flip.
Yeah, and Tammy's going, look, he disappeared. He took himself out of the group.
And if one person folds, think about this. The whole house of cards comes tumbling down. It's going to be like a Jenga game.
Todd. That's
The
right.
whole thing comes down.
And it is a house of cards. That's a great analogy. All it takes is one. And if it's the feds applying the pressure as opposed to a civil litigation applying the pressure, the feds can be extremely persuasive, especially from a federal standpoint. The feds may have their own targets here. They may be interested in different things, not all of the McAlberts and Higgins, etc. They may be interested in Morrissey and those, the law enforcement that are tied into this. And once the other parties that may not directly interest the feds realize this, they may be offered deals to kind of turn state's evidence and fold, say what they know, give proffer interviews to answer questions to save themselves, because they know, okay, I'm not a target, but I'm at risk here unless I tell the truth. I think that's happening, and I think it's happening right now.
Look at this. Ty Girl says, hey, they'll flip on Higgins. So that could happen too. They just get out ahead of it and they flip on him. Prosciutto's saying, does the first wheeler get the best deal? I guess that's all going to depend.
That's my opinion, but that from my practice, that's usually the case. The feds are laser precise in who they focus on, and it is kind of like a first the first person who squeals does seem to get the best treatment.
And Todd probably knows about that in interrogations and stuff like that, working with, you know, in working with, you know, arresting people and getting people to talk, you know,
Yeah,
and
who's going to clean up their false memory?
yeah,
Yeah.
exactly.
Yeah. And by the way, that person who folds, a person who folds could be someone like Kelly Dever. Now, she's not, she's just, she was on the periphery. As much as no one liked her, and she's got the worst memory known to man and made a bad decision in court, she chose the wrong horse, so to speak. She didn't do the right thing. With that said, this is an example of someone on the periphery who, had she made a better choice, it would have ended better for her. She may flip. The fact that she's no longer employed by the BPD is an indicator to me that she may possibly flip, although it also is an indicator that, on the other hand, she may have signed a non-disclosure agreement and received some type of severance and kind of went on her way, did her duty, lied on the stand, and is now going to ride off into the sunset, not being in law enforcement. But she could be a person who flips. You never know.
Hey, apparently the chief knew nothing about it. I didn't even know who Karen Reed was.
I was in Michigan. I was in Michigan.
Yeah,
so
wink,
bad.
wink, nudge, nudge.
Oh
really
God!
bad.
It's like, come on, dude. Come on. It's like the most talked about thing in the state, like the last 2 years. And you're in law enforcement. You all talk about this. There's no way that you didn't know about it. I didn't even know who Karen Reed.
It's so bad, so bad.
It's the worst, like, stage show I've ever seen.
You know, when that interview was aired, I'm like, no, not you too.
I would have loved to see Todd's reaction.
Like, we gotta go, and like drags him away.
Yeah.
I would have loved to see Todd's reaction real time of Cox's interview that day. Just like see Todd just head in hand going, what is this guy doing?
It was
like
fingernails on a chalkboard, man.
Yeah.
Quote, this case is over. Yeah, this case is over. I love it. And Buzzing for the Truth, thank you so much for being here and being a member. All right, let's go back to the presentation. Great conversation tonight. I love this. So look, we'll take one of the major players here, the homeowner, talk about Brian Albert. So the risk of a civil trial discovery, Brian Albert is going to be deposed. He can't dodge from direct questioning about what happened in his house, who was present, what he saw and heard, and what was said after O'Keefe's body was found. And the civil liability in this is the evidence shows O'Keefe was injured inside the home. Alberts could face liability for wrongful death, negligence, failure to call 911, concealment. And then you have the credibility issue. Any contradiction with prior testimony or refusal to testify on the criminal trial locks him in to a credibility trap. And that's what you get with a civil trial. I mean, this just opens up every single thing. There's no more, I didn't know, I didn't hear anything, the dog didn't wake me up, like all this crap. You're gonna have to answer for it. And that's why I love depositions. If you haven't, go watch some depositions online. They're great. I watched them.
Brian, when he was interviewed by the media, he stated that by the time he kind of got dressed and got himself together, that John had been removed. And he finished his sentence by saying, and the officers were already in my house.
That's a good point.
I don't know.
That's a good point.
You know what I'm going to say? There's meat on that bone.
Always. That's the thing, though. In civil litigation, you can get at so much more meat on that bone. It's really it's a smorgasbord as far as I'm concerned.
I know. I love civil trials. All right, here we go. So let's look at the other major player in this. I call one of the other major players, of course. We have Jen McCabe, cell phone and deletion risk, subpoenas for Google's deletion. Thank you. Why did I say deletion? Subpoenas for Google searches, deleted texts, and full extractions could expose discrepancies in her timeline. The Hostline to Die and Cold search, of course. So we're going to get to see everything. The deposition pressure, civil attorney can grill her on the inconsistencies between the criminal testimony, police interviews, and phone records. credibility fallout. If she's caught lying or evading, it damaged her not just in the case, but the entire defense narrative. And I love
Yes.
that. Go ahead, Nan. I know you probably want to speak to
That last bullet is probably the most important for me because Jen, we all have our feelings about Jen McCabe, the normal mom. But if she
Soccer mom.
is evasive, if she gives testimony either in her deposition or at trial in the civil action that in any way conflicts with her prior testimony, which it will. All of her testimonies have conflicted with one another from the grand jury level, then to 1.0 and then 2.0. There has never been a consistent story from her. If she is found to have credibility issues, it doesn't just harm herself as a civil defendant, it can unravel all of the defendants' defense.
Right. All the defendants. Yeah.
Yeah, she's probably the biggest risk to all of the defendants in this matter. Not to Karen. Karen is a defendant in this matter, but Jen could compromise all of the other defendants.
Yep.
And I think that's poetic because she's the one who Googled at 2:27 a.m. Long to die in cold, which tells you everything you need to know about her as a human being.
During her testimony, she gave a very explicit, almost a timeline of when coming from the waterfall, when Karen and John arrived, the sense of, well, they pulled up in front of the driveway, then they pulled forward, and like very, very methodical timeline. That's low hanging fruit to start, really impeaching her testimony.
Agreed.
Yeah, I love it.
I agree.
Then we got I'll just say four stooges in this. So we have the MSP investigators, obviously internal affairs, exposure, civil discovery, and can force the release of misconduct files, disciplinary history, and prior complaints. So we may see some prior complaints in there too that we didn't see in the criminal trial. Maybe there is something on record. Maybe there are some internal affairs documents that we haven't seen, complaints and whatnot. Bias and misconduct risk. Defense attorney will hammer at Proctor's text messages once again. Alleged conflicts of interest and omissions in the report. We have deposition vulnerability. Unlikely in the criminal court where the DA shielded them, they have to answer line by line about the investigative decisions. And I love that. Civil liability. This could be exposed. Claims of conspiracy, fabrication of evidence, and malicious prosecution. I love that slide, the second one from the bottom. They will have to answer line by line about investigative decisions. And Todd, I know you've spoken a lot about this, of how the mishandling of this case, they will be pressed harder, I assume.
Brian, investigations are done in teams. And the low-hanging fruit is, why were certain people not interviewed within the first 24 hours of the investigation?
Mm-hmm.
Key players were not interviewed in the first 24 hours of the investigation, which means in hour 12, when he made up his mind to pin it on Karen, there was no reason to conduct any other further investigations.
Yep. And then when he's writing his reports and warrants, he's texting his buddies and going, oh yeah, this and that, and saying all the awful things that he said about Karen. So his mind was already made up. So then we have the Canton first responders, the timeline discrepancies. You can bring the EMT, bring the fire back in. Canton police may force the question about what they saw at the scene versus what reports said. Chain of custody issues. No more of the shit about, oh, I didn't know or I didn't see anything. They're going to press them. They're going to press them on the hard questions. And again, if one of them start falling apart, this is kind of the domino effect with all of these players involved, all the connections involved to all the first responders. And that goes for MSP as well, too. Chain of custody issues. Civil attorneys will scrutinize how evidence, blood, hair, snow, car pieces were collected and preserved. And then you have the exposure to negligence claims, which is shown that they didn't properly secure and report what they saw. They risk it being tied into a negligence claim. So how does that work, Nan? So if they're found, if this goes into the negligence claim, probably the proper thing to do would be the O'Keefes to sue them, but we know they probably won't because they're rolling with this narrative with
Yep,
the major players here, right?
that's
So,
right.
yeah.
So this kind of ties in with what I was saying earlier, which is, look, there were, at an absolute minimum, missteps by the Canton PD in the investigation. Even if you were to presume or assume that the suspected culpable parties who were inside the house, let's assume they didn't do it. There was still very likely a finding of negligence on the part of the Canton PD in how they responded to the scene, performed their investigation, and possibly those things could have affected the outcome, perhaps. Who knows? I don't know. What I can tell you is the O'Keefes absolutely should be suing the Canton PD because of how that car, the Lexus, was examined, investigated, how the Sally port was maintained and controlled, whether there was access that should not have been afforded to certain individuals to avoid evidence tampering. These are legitimate avenues that the O'Keefes should pursue. I don't think they're going to, and that may end up being malpractice on the part of her attorneys if they don't
Crazy.
now do it.
Yeah, they're not going to roll. They're going to roll with this, continue to roll with this narrative because Karen bad, Karen got to get Karen. Karen did this, Karen bad, got to get Karen. That's the mindset and the mentality here. Even though, and I talked about this too, and personally, this is just my opinion, I think their ass is going to get handed to them 3 times over here because we just went through 2 criminal trials that literally proved that Karen Reed did not hit John O'Keefe. It factually did not hit John O'Keefe. And scientifically, she did not hit John O'Keefe. And they're going to go forward with this bogus lawsuit on a whim and a prayer of a civil attorney to say, hey, we got it and we're going to win. Can you imagine the firepower? And I'm just saying this figuratively speaking, that's on the other side on Reed's team. I mean, she has the most expert lawyers there that are going to dismantle this one by one. You have, in my opinion, you have absolutely no chance in the civil trial. And you have Jackson there that's going to be able to help the civil lawyers along because obviously he was part of both criminal trials. I just don't see him winning.
Yeah, I mean, adding Jackson and Little to the defense team, it took their defense and put it on steroids. Now they're going to go on the offense, which is great. It's really foolish for anyone who has felt painted into a corner or has to defend oneself. It's foolish if you don't then turn that around and use it as a strength and actually fight for yourself. And that's what Karen's going to do here. And I admire that greatly. But adding Jackson and Little, that's going to streamline discovery significantly. They controlled these files.
Yeah.
They have everything, I'm sure, down to a very sophisticated archival system, things they know like the back of their hand. It's going to be a tremendous advantage to them. And I'm here for it. I really am. It's going to be good.
And I don't think, and I was watching the Billy Bush interview before we did this live a couple of days ago. And, I think Jackson's basically just, and he may just kind of backseat this. He's like, I just really let her civil attorney talk. I think he's just going to be there for hands, and he's like, I'm not a civil attorney, but I think we've been saying he knows this back and forth. He knows the case. He's going to be able to help. Let's do a couple questions here before we move on. Todd, anything you wanted to add to that kind of segment or?
No, I'm tracking with you and Anna saying, great stuff coming in from the chat as well. It's just, it's interesting because we talked about the first trial, then we talked about the differences in the approach in the second trial. Here we are, we knew that the civil trial was coming, but again, a brand new look at how the attorneys are going to take on, this case. And, of all the things, it's something else I was reflecting on, and this was mostly the McCabe's, the Alberts, and in the law enforcement witnesses. When Jackson would ask a question, a lot of the witnesses would look at Cannoni as if to say, "Okay, save me on this.
Jump in here." Yeah.
They're not going to have that this time.
Yeah. Yeah.
You're not going to
There's no
have
more
that.
protection.
So, yeah.
I love it.
gonna be
Let's do a couple. Go ahead. I'm sorry, Dan. Todd. Dan.
Okay,
I just said Dan.
That's okay. I
I
know
just
who I
combined
am.
Todd and Dan.
I love it.
What did we say the other night? What did I say? That
Nansers.
We get Nansers.
I was sitting in your chat and I was just answering the legal questions while I was like sitting there in my pajamas. It was great.
And I slipped and I said, we'll wait for a Nancer. And I was like, oh, we need a t-shirt that says Nancer on it.
You should see me running around my house sometimes, guys. I got the headphones in. I'm like, oh, wait, they got a question. And I give the answers. I love it.
That's funny. Viola says, can they say, I don't recall? They can try. But they're not going to be able to do that. There was another question.
Feel free to keep them coming. I would just tell the person who just asked that, it's like, you can say I don't recall, but if you previously answered a question in a criminal proceeding, then you're going to get impeached if you're saying I don't recall now, but you remembered at a prior hearing, they're going to show you your prior testimony. And juries are very attuned to whether a witness keeps saying I don't recall, I don't remember, I don't know. Was it who was the witness who was it the boyfriend of Caitlin Albert? I forget his name. He didn't know anything when he testified in 1.0. Is I don't know, I don't remember, I don't know. He didn't even know his own name, I bet. That comes off as unbelievable. So
no credibility.
None. Right.
Yeah.
You got to watch
Tristan
how you
Morris.
use it.
Yeah, Tristan Morris.
Tristan.
Kim's asking, can they put Brennan on the stand?
No.
Okay.
No. I mean, there would be no reason to unless there's a specific, legitimate, relevant claim. Like, I'd have to see something that's pled in the civil rights action that impugns Brennan's conduct, and then he becomes substantially relevant. But no.
I mean, he was just up there, and he's just doing his job. He was just doing the job and trying the case. He really doesn't have any, dog in the fight in the sense of that. I know everybody hates him. Of course I hate him, but he's just doing his job. So again, I asked the question at the very beginning of the stream, and I just asked the O'Keefes, are you going to be ready for this? Are you going to be ready? Because you got a lot of responsibility now in the civil trial. So we look at the bigger picture. The big picture is the civil discovery strips away the DA shield. That is very important for people to understand that in the civil trial. And I keep hammering that home. Everything is on the table. These individuals can't rely on prosecutorial discretion anymore. The lawyers will subpoena phones, emails, documents, and demand straight answers. Risk isn't just embarrassment. It's perjury, civil liability, and reputation to ruin if contradictions are exposed. I'm going to tell you, there's probably going to be a lot of contradictions that are exposed. And then we can look at this graph that I put together. Plaintiff risk chart, O'Keefe civil lawsuit. We look at depositions, family members, and what could come out. Family members and reps forced under oath, cross-examination on inconsistencies since 2022. The consequence, we have risk of perjury, trap, contradictions, damaging credibility. You look at John O'Keefe's history, medical reports, alcohol use, relationships, prior incidences, and what's the consequence? It could shift focus to personal factors instead of blaming Karen Reed. We look at the financial claims, scrutiny of dependency, damages, calculations, motives for the lawsuit. Remember, if it's money, that could all come out. Some motive could come out. Defense could argue financial incentives or ulterior motive. And then we have counterclaims, defamation, or abuse of process if claims are false or misleading, exposure to legal liability and financial penalties. We have reputational fallout, evidence contradicting the DA's narrative surfing in discovery, and then the consequence, public credibility damage, weakening trust in their case. And then finally, loss of narrative control. Reed's attorneys could present alternative timeline, subpoena new records, and the consequences, the story could pivot to events inside Albert's home, undermining O'Keefe's family framing. And then we have the bottom line. By filing the civil case, the O'Keefes gain a platform, but also risk losing the control of the narrative. Defense lawyers will now pry into areas that were shielded by the criminal trial. And if damaged facts surface, it could backfire on the plaintiffs themselves.
That's one hell of a bottom line right there. That is
Yeah.
probably the best way to summarize the this civil litigation right now. They had to
Mhm.
file it. They had a statute of limitations, but there is significant risk that they are facing, and they can lose control of this narrative. I
100%.
I think if anything, the O'Keefes have to also name these new 10 defendants. They have to. They have to do it because that's the only way they're going to increase the likelihood of getting true justice. And it's really never true justice, but a way to compensate themselves properly against all responsible parties for the loss of John.
I love that, Dan. I would love to see that. I just don't think it's going to happen because I go back to that dumb caveman mentality of Karen bad, Karen did this, Karen, Karen, Karen. I just don't see it happen because it's not going to follow through with the narrative that they've been holding. They just so blind to the truth at this point. And for whatever reason is like, I don't get it. Like you literally just sat through 2 trials with well qualified experts that forensically cleared Karen Reed of anything. Look at,
Yeah.
Karen's not a saint. We saw that shit come out, but she certainly did not kill John O'Keefe. This just scientifically did not happen. It was proven. And I don't see it. I think they're going to keep rolling with this. And it's sad because I really want to see justice for John. And this just pulls away further from getting to that truth.
Yeah.
Brian, Yannetti and Jackson came out very early in both trials with the conspiracy theory. And many thought that was too far of a reach. Just focus on reasonable doubt. You've got enough forensic evidence to benefit you, the science, all the different things to benefit that aspect in a criminal trial. The civil proceeding is the better forum to be able to make those allegations and then try to make those connections as opposed to a bridge too far. So I hear what you're saying about Karen's a bad girl and that's the lens that everyone's looking through. But I think the better argument now is for the legal team on Karen's benefit is in a civil proceeding.
Yeah, I listen, I'm not getting down on her, but I mean, there's some things that came out, like, look, a lot of her private conversations get exposed and there's arguments and all that, whatever, I mean, but I'm just going to the fact of she didn't kill John. Forensically, she didn't do it. She didn't make contact with John. John didn't make contact with her vehicle. There's just no way possible that it happened. And I'm just sitting here and I'm going, they just sat through these, like 2 of these trials. I would have thought by maybe the second trial that we've gone through this and it was more scientifically presented, that's what was really great. It was more scientifically presented this time around. And, if you're sitting there with the family, you got to be going, you know what? A lot of this shit on the defense side is making a lot of sense to me. I mean, you're really seeing top class demonstrations in front of your eyes opposed to blue paint guy, Smurf man, and
Finger paint.
with the cringy, like we're gonna dress up the John O'Keefe cosplay, and you got to look at Aka and like, okay, what makes sense here? I mean, if I like seriously, if I presented both of those presentations to someone that didn't even know anything about this trial, and I said, here's one set of a way that they're saying that this person died, and here's another here's another group of people that have put a presentation to say, what are you going to believe in this? I'm going to tell you right now, 99.9, I might even go on record and say 100% of the people are going to pick Arca. It's then blue paint man.
Yeah. And by the way, thinking about ARCA, one of the interesting things is that when ARCA comes back, and they will, for the most part, Karen's insurance pays for them to come. So I just wanted to point it out while we're mentioning ARCA. It's going to be a big difference between Karen's insurance, which is providing her defense right now, or at least the large bulk of it. I don't know the granular details, but her insurance will pay for her experts. And then she, I'm sure, is free to pay for anything above and beyond if she wants to, further build up her arsenal for defense of this suit or to advance her civil rights claims. But that is different as juxtaposed to the O'Keeffes. The O'Keeffes are going to be out of pocket for their experts. And frankly, I think they should find a different one other than Aperture.
Yeah. And Shelley's asking, the O'Keeffes add the 10 new defendants now the statute of limitations have expired.
Yeah, it's funny. That was a great question, and I was thinking about that the other day. That's the answer to that is probably in case law that I did not research. My off the cuff answer when I thought of it the other day was yes, but I would imagine that those parties, those 10 new parties, will file some type of motion to try to get it dismissed. And say no, they're out of time, and I don't know what the case law says as to what the judge would decide, but I think they can add them, but I'm not 100% certain without doing research. It's an interesting legal issue.
Yeah,
that's why they should have named them all together, because there's something called the entire controversy doctrine. You have to name all of the potentially culpable parties when you file a lawsuit. You don't just cherry pick and say we're going to go after Karen and the bars. You say it's possibly all of these people and let them duke it out. So it is possible that the 10 new defendants are barred with regard to statute of limitations as it applies to the O'Keeffes. I'm not certain without research, but it's a great question you had there.
I know that you said something about when Karen's team, added in the 10 defendants. And in my kind of speculation about that was, you said, they could have done that under a motion. I think they wanted to get it out there on camera and just say, hey, we're bringing all these people in too, so they know, be prepared because you're going to get dragged in this. And they wanted it to be public and wanted it to be talked about, of course.
Yeah.
Because, look these are all the people that came against Karen and fabricated all this story and these lies and this evidence against her. Like, all right, so pony up, because if you're not going to be squealing out of this one, we're just going to drag you into it as well. And I love that they did that. And it was great. And I think it's good to let the public know, like, look, the people that were involved in this are not escaping. They're going to be, dragged in this as well. So it was a good little power play.
Yeah. For me, I had a little bit of a stylistic difference, or I had an opinion as to the manner in which they did it.
Yeah.
And I explained it on a stream on this past Saturday night. It's a style. It's a matter of, do you just say it to the court, or do you file your pleading or exchange it with the other party and be ready to roll? I would have presented it differently to the court as opposed to just simply saying, we're going to do this. I would have said, this is what we're doing, and let a judge tell me not to. Yeah. But, two different attorneys can do things and approach things two different ways. And I respect the way I do it, and I respect the way they've done it.
Yeah. What was I going to say? I just lost my train of thought. Oh, earlier in the chat, someone said about Sergeant Barrows. I put the police log out there and his report out there today, and I wanted people to be able to see that and see what he said. And then obviously we had we had more to his testimony during the first and second trial. I'm also working on some other things too, so stay tuned, because I'm digging a little bit deeper as I'm getting some more things. And obviously I released the body cam footage and some in-car camera footage. And, I want people to know this, and it's nothing that wouldn't be brought into the civil trial too. They may play some of this, but I wanted you all to see what was out there and be able to see, the way that Karen was treated through this. And have transparency in this case. And I am digging more. There's some more things that I'm kind of biting at right now. I was surprised I got the Barrows call log.
Yeah.
And I'm working on some more things that involve him. So hopefully it will come through and we can, get more of that. What was I going to say? Nancy says this was very informative. I appreciate that. Linda says Todd and Nan are brilliant, and they are. They're so great. And this is why this panel's work really well. Before we finish up, I want to take 10 minutes because we kind of had that joke about Chief Cox at the very beginning of the stream, and I want to play this mashup that I did of Deaver and Cox, and I want to play her testimony and then Cox's response. We'll end with that. And again, I want to thank my two guests for being up here, Attorney Gallagher and retired Mass State Police Todd McGhee. This one's probably like an 8-minute video. Let's watch this and have a laugh.
Have some fun.
Because apparently he didn't know who Karen Reed was, and we'll be able to see through that.
Last year sometime. You remember that?
Yes.
Between the time that you were interviewed on August 9th, 2023, and when we spoke sometime in maybe it was April or so of last year, does that sound about right?
Yes.
Did you have any conversation with any other party about your potential involvement in this case?
No.
Did you have a conversation with anybody in the commissioner's office at the Boston Police Department?
Not about anything malicious.
I didn't use the word malicious. Why do you say malicious?
I had a conversation, but it was my department saying, regardless of what I need to say on the stand, they support me.
You were asked to go to the commissioner's office, correct?
Yes.
How long had you been on the Boston Police Department at the time that you were invited to go up to the Commissioner Michael Cox's office?
It had to have been before the first trial. So, and I know it was when the agency released information to outside people.
That's not my question.
Okay, so I don't recall.
Okay. You don't recall how long you had been on the force, generally, at the time that you were called up to the commissioner's office, on the Boston Police Department?
No.
Was it 5 years, 2 years, 2 months? Give me a ballpark.
So I've been on the department for 2 years and 2 months. I would say somewhere in the range of a year.
Okay. Did you find it unusual would you call yourself a rookie back then?
Yes.
Did you find it unusual that a rookie police officer would be called up to the commissioner's office personally to discuss a matter?
It was a reflection of how good of a leader he is. It was not anything that I found unusual, given the fact he is someone who wanted to show support for his officer.
So I'm guessing all of your training class or all of your entry class at the Boston PD, they've all gone up to the commissioner's office as well?
I don't know anyone else who's been in this particular circumstance.
Do you know anybody else who's been called up to a commissioner's office at your level at the Boston Police Department?
Objection.
Sustained.
Do you know of any of your colleagues with your level of experience that have been called up to the commissioner's office for a specific instance?
Objection.
That's sustained.
Now, when you went up to the commissioner's office, did you respond to his invitation? He wanted to see you up in his office.
It wasn't a direct line of contact from him.
Okay. Did you respond? Did you ultimately go? That's what I mean by respond. Did you go to his office?
He's my boss, so yes.
Okay. And who else was in that office?
Not anymore.
Yeah.
Me and him. The two of us.
General counsel of the Boston Police Department?
No, it's just me and him.
During the conversation that we had last year, did you say that general legal counsel for the Boston Police Department was also there?
Objection.
Not during
Sustained.
that conversation.
Objection.
Next question.
Sure.
Not in the
Was there
civil
another
case.
time that you went to the commissioner's
Right.
office, the general legal counsel was there?
No.
Have you ever met general legal counsel from the Boston Police Department?
Yes.
Was it in the commissioner's office?
No.
When was it?
During my conversation with the agents.
You took
Ed.
a lawyer with you to talk to this other law enforcement agency?
I'm gonna see you at sidebar on this.
Ugh. It's painful
that
every
face.
time I listen to her.
Veruca Salt.
May I continue, Your Honor?
Yes.
Thank you. Ms. Dever, when we left off, I was asking you about the meeting at the commissioner's office.
Thank you, Teresa.
And I want to clear this up. Was general legal counsel in that office or not when you had a meeting with the commissioner, Michael Cox?
No, it was just me and the commissioner.
At some point, did the commissioner say to you that Boston Police Department, insofar as your connection to this case is concerned, Boston Police Department fully supports you?
Yes.
Did he also say, do the right thing?
That's a direct quote. So
Oh.
I can't recollect if he said a direct quote 2 years ago.
A year ago, when you talked to us, the defense, did you tell the defense that when you were called up to the commissioner's office, he told you two things? Commissioner Cox told you, number one, Boston Police Department supports you, and Officer Deaver, do the right thing.
So he said my name correctly. He said Dever. And
That's my mistake. Let's see, like, you want me to repeat the question so I get
So,
that right?
Mr. Jackson, let's go ahead and answer, please.
yes, and he said nothing with the intent of guiding me one way or the
I didn't ask you
other.
what his intent was, madam. I asked you what he said to you. What were his words to you?
That he supports me.
And
Just wanted me to tell the truth up here.
his words were, do the right thing, correct?
I don't recall.
Yeah.
So
sure.
painful.
Your
Yeah.
name came up during the recent Karen Reed trial. You got a visit from Officer Kelly Dever. The defense implied that you influenced her testimony. Do you want to respond to that?
I have nothing to do with Karen Reed. Matter of fact, I didn't even know this person was associated with the Karen Reed case. You know, I have an organization, Philip, over 3,000 people, and we support all our folks. And the reality is that, you know, I get information passed on, whether people are high or low, and I encourage everyone, right? And if you're going to work here and you belong here, then we're going to encourage you. I have no idea what they're talking about with Karen Reed. It had nothing to do with Karen Reed. No discussion about
Did you
Karen
tell Officer Dever to do the right thing?
I didn't know she was even associated with that case. So, you know, I don't know. I was struck. Like, what do I have to do with the Karen Reed race? I've never have said those words together. And so the fact is, you know, it's much to do about nothing. We have employees here that we have to develop and encourage and do things, and I do that for tons of our employees.
Wow.
Do you feel that you were inappropriately drawn into this as some sort of
That,
boogeyman?
that case is over, and you know, we've got a lot of other stuff to talk about. I have nothing to do with Karen Reed. I was in the state of Michigan.
Oh, Brian.
Brian,
Like,
statement
I-
analysis, he deflected at least five times in that 45-second snippet. You know, he doesn't even mention Dever's name. You know, the last comment of Michigan further trying to distance himself. It's just, I lost a lot of respect for him.
Right there. There's the quote. It's not much to do about nothing. The case is over. It's incredible. I just love that mashup because you get her on the stand, literally saying she went to Cox's office. They had this conversation, and he goes, I don't know anything about it. I was in Michigan.
I love Todd's analysis of that because that is like really, really telling to me. That's what a talented law enforcement officer knows how to pick apart these statements. I look at it and go, oh my God, this guy's just a liar. But to see the analysis there is key. Also, he like never answered the question, you know, he's just talking in circles, never answered the direct question. And lastly, he's when I thought this when that interview came out, Cox is being asked these questions, and my biggest takeaway from that was that he said, if you're going to work for us, and he said something else, like if you're going to work for us and we're going to support you. So it's almost like a little threat. Like if you're going to work here, we'll support you. I have a feeling he probably said that very type of statement to her. If you want to work here, or if you want to stay in this cushy position at the BPD as a rookie making $140-something thousand a year and the day shift, then you're going to do the right thing here. I think there's going to be more to come with regard to this because this is law enforcement. There may be some type of corruption going on, and that is something that the feds investigate. So
I
stay
agree.
tuned.
I love that. And we'll end on that tonight. I want to end on this really quick, though. Lauren DC in the chat, member for 11 months. Friday is my
Aw.
1 year since my first appearance on LTL. And I will say, Lauren, I love you. You are my friend offline. I am so glad that I've met you. I'm so glad that you're in my life. You have been a real friend over these last 12 months, almost a year of us knowing each other. And I appreciate your company. I can appreciate your candor. And when I need to be slapped around and talked to, she gives me that talk too. So
Yeah.
she's great.
Congrats, Lauren. You're the best.
She's a great
Lauren.
friend, and I have two great friends on this panel as well too. And I appreciate the both of you and for being part of these Monday night panels. And it's nice to kind of be back in our rotation here. And you know, both of you lending your time and your expertise to educate this audience. And that was always, you know, the theme of this channel, just to open up a panel of conversation and get, you know, people that are informative and want to come here for information and learn. I've learned so much by having the both of these wonderful people on my panel, and I hope that they give back to you, because I like to bring them up and showcase the world to this this talent up here. So great live tonight. Really,
But you
really
know
good.
what? You know what, Brian? I speak for Todd. We learn a lot from you. We really do, from your questions and how you look at things. And I'm pretty confident. I'm assuming you agree, Todd. Like, one of the reasons I come back is because I want to hear Brian's perspective and how he lays out his analysis, because it helps me change or revisit my own analysis. And I feel the same way about you, Todd. Like, I want to hear your opinions. I love this little ecosystem, which I feel helps advance me professionally when I analyze these types of cases.
Yeah,
Yeah,
and there's
I was
Go
just
ahead,
going to
Todd, I'm
say, when you come on in this role, you can't fake it. You're exposed, and you know, to sit here and mumble over words, or not be able to address answers, you know, from the chat or directly from you, Brian, or in Nan, you know, it's you got to bring your A game, and I think your audience expects that, and that's if I can speak for Nan, that's, I know what she brings to the table as well, is that level of
Oh,
expertise.
thank you.
yeah, we're live, so whatever comes out, it's gonna come out. It's live. You know, you've gotta you've got to know your Q's and P's. Is it P's and Q's or Q's and P's? P's and Q's.
P's and Q's.
P's and Q's. Anyway, but that being said, the wonderful Nan Gallagher and the awesome Todd McGhee. And I thank everybody for joining this panel tonight. If you haven't, make sure to subscribe, comment down below, comment after this post. We'd love to, you know, get you here on this channel and get you subbed up. Real quick, Joy, $2. You sent me your email, but I wrote it wrong. I'm going to do this for you, Joy, before we go off air. I want to let these two people go, because I've taken too much of their time tonight. You can go right there and copy it. The Nightbot just dropped it. And with that being said, we're out of here. Thank you so much, everybody. Have a great night, and we'll be back soon. Take care. Bye-bye.